Welcome to Creamer Media's Polity. I'm Amy Witherden. I am at the offices of law firm Wentzel in Ilovo to meet with Okyerebea Ampofo-Anti to talk about media law and the new Protection of Information Bill. Okyerebea, in a recent Wentzel Media Practice Group newsletter, the issue of the protection of journalistic sources was discussed in relation to a recent Canadian Supreme Court ruling. Please explain this ruling.
Well, Amy, the case that you're referring to is called R versus National Post. And what happened in that matter was that a journalist that worked for one of the big newspapers in Canada, the National Post, was supplied with documents by an anonymous source. And those documents showed that the then Prime Minister of Canada had been involved in improperly using his power to pressurize the Business Development Bank of Canada into giving a loan to a hotel called the Auberge Grand Mère. And the reason, the alleged reason for this was that the Auberge Grand Mère owed the Prime Minister's family company a certain amount of money, which they were not going to be able to repay because they were about to go insolvent. So basically they were bailed out by the Business Development Bank of Canada on the Prime Minister's orders. Of course, no journalist would pass up a story of that nature, and this story was promptly published by the National Post. Later on, further documentation came to light, and the journalist who was responsible for the story decided to fax that information to both the bank and the Prime Minister's office and ask them to have a look at the documents and to give their comments on it. And predictably, both the bank and the Prime Minister's office denied the authenticity of the documents and denied, all involvement in this scandal. The bank also went and laid a complaint with the police, claiming that those documents were in fact forged. This led to a police investigation into the matter, and the police decided to request a search warrant to search the National Post's premises. This order was initially granted by the High Court, and they attempted to carry out the order. But of course, the National Post decided to challenge the search warrant, and the matter went all the way up to the Supreme Court of Canada. Well, the Supreme Court of Canada made a number of important pronouncements regarding confidential sources. Firstly, they again reiterated, as has been the case in previous case law of the Canadian Supreme Court, the importance of journalists in a modern democracy, because journalists obviously are the ones who ensure that the public is informed of all the matters that go on behind the scenes, which we would otherwise never get to find out about, and particularly when it relates to people in high public office. The court also reiterated that it is important for journalists to be able to keep their sources confidential in certain circumstances, because otherwise there may be certain cases where information would never come to light because people would simply be too afraid of persecution to come forward and speak to the media. What the court refused to do, however, was to grant the National Post an order that said that journalists are always allowed to keep their sources confidential and that there's a general privilege regarding disclosure of journalistic sources. The court said that whilst there is that important aspect of keeping sources confidential, which is part and parcel of the media's ability to practice their craft, it would really be impractical to grant a blanket rule that says that you can always keep sources confidential. And the reasons for this were really, I can summarize them into two major points. The first one is that it's not only the media that has the right to freedom of expression. Every person that blogs or tweets or posts something on Facebook or decides to publish a local newsletter has also got the right to freedom of expression, and they can obtain the same protections that the media can. And of course, all of those people are not necessarily subject to the same types of rigorous control that a reputable media institution would be subject to, no editorial control, etc. So you cannot afford to allow all of those people to keep their so-called sources confidential, because then it would really be a serious assault on other constitutionally protected rights and interests such as law enforcement and even the right to privacy. We can all imagine what would happen if every person was allowed to publish whatever they liked and then keep the source of that information confidential. Number two, importantly, was that a balance needs to be sought between the right to media freedom and other interests which are equally important in society, such as law enforcement, which was really the issue which was at stake in this case, because there was an allegation that a crime had been committed, that the Prime Minister had basically been set up by somebody who had forged these documents. So because of those considerations, the court said, no, we're not going to have a blanket rule. What we are going to have, though, is a case-by-case analysis to see whether or not a journalistic source should be protected given the circumstances of a specific case.
Further to the security of information that may be sensitive to the state, please discuss South Africa's new Protection of Information Bill.
Well, the Protection of Information Bill is a piece of legislation that first appeared on the scene in 2008. And it was withdrawn amongst a lot of public criticism because there are several extremely draconian provisions in the bill, particularly with regard to the impact that it could have on the media. Now, there are a number of issues that were of concern in the bill, or perhaps I should first start by outlining what the basis of the bill is. The idea behind this bill is to provide a legislative basis for the state to protect information that has an impact on national security. That's the basic idea behind this bill. And it deals with classification of documents that are in possession or information in general, not necessarily in documentary form, that's in the possession of the state. And it provides for different levels of classification with different levels of access. So there's the level of confidential, there's secret, and there's top secret. And that all obviously the terms imply, depends on the nature of that information. So that's the basic idea behind this bill. And of course, it's a bill that is needed in every modern state, where we all know that there's a lot of risk to the state in terms of disclosure of information that really shouldn't be out there, from criminal elements, from hostiles, and from terrorists, etc. So whilst there's no quibble with the main idea behind the bill, the problem really is the manner in which the state has chosen to implement this legislation. And there are a number of problematic aspects of this bill, but if I could just highlight a few of them. One is that it creates several offenses relating to the possession of confidential, or rather of classified information, and in some instances information that has not even been classified at all, the disclosure of classified information, whether it's by secret agents or even by members of the public who happen to possess such information, and the publication of such information. So and none of those offenses actually include a public interest defense. And that, for us as media practitioners, that is one of our primary concerns around this bill, because it creates a situation where if a document has perhaps been improperly classified to protect some state official, you can think of something like the arms deal, where there may be confidential information involved, because not everyone in South Africa should necessarily know everything about where, for example, all the arms in South Africa are kept, etc. But that type of information could also reveal some kind of impropriety on behalf of certain members of the government, as we've seen with all the scandals around the arms deal. Now, if that type of information were to be classified under this act and were then to be subsequently published by a media organization such as Creamer Media, you would find yourselves being prosecuted for that, and you wouldn't have a defense. You wouldn't be able to say, but this proves that such and such member of government is actually corrupt. That's not a defense that the court will be able to entertain with this type of legislation in place. So that's where the crucial problem lies. And then secondly, there's also a serious problem with the classification regime in the bill itself. It allows for speculative harm to result in classification. So, for example, a document could be classified if it may endanger the national interest. And that is obviously, I mean, it's pure speculation to say that something may endanger the national interest. And one would think that in order for information to be put beyond the reach of public scrutiny, there should be a higher probability or likelihood that this information could have a negative impact on national security. So that's number two, the speculative harm issue. Number three is the excessively wide definitions of certain key concepts that form part of the core of the bill. To focus on just one of these, the concept of national interest, which is really the linchpin for many of the classification levels in the bill. National interest is defined so widely that it could include every possible aspect of a citizen's life in South Africa, such as the resolve of South Africans to live a peaceful and democratic life. I mean, one could really argue about what the content of that is, and a document could be classified if it may endanger the national interest being the resolve of South Africans to live peacefully. So those kinds of concepts are very dangerously elastic, and they definitely need to be narrowed down in order to bring this bill within the boundaries of the Constitution. The other issue, which is extremely problematic in our view, is the protection of commercial information, including the commercial information that belongs to private entities. So, for example, if there were to be a tender and documents were to be handed into the state, potentially those documents could become classified once they're in the hands of the state, depending on the different levels of, again, speculative harm that they could cause even to the business of that private entity. And that is seriously problematic, because one questions why the business interest of a private entity should be protected by the state, and particularly in circumstances where that results in an offense being committed if that information is subsequently published. So again, to cite an example, we would be looking at a situation where there's been some kind of tender irregularity and the commercial information has been marked classified, top secret, or whichever classification. A journalist gets hold of it and publishes it, and it's out there, and we all know that there's been a tender irregularity. But because the document has been classified, an offense has been committed. And then again, we go back to the issue of no public interest defense.
How does the new draft of the bill differ from the draft that was withdrawn in 2008?
Unfortunately, Amy, it looks as if the new draft of the bill has not taken into account any of the considerations that were put forward during the first round of public submissions in 2008. This draft of the bill can actually be described as more draconian than the previous draft in a number of important respects.
In terms of some of the case law surrounding this issue, how can a balance be found between the right to freedom of expression and the need for protection of sensitive state information?
Well, this is an issue that has not been fully explored in our case law, even though overseas it has been explored to some extent. And to sum it up, basically, what the case law indicates is that there shouldn't be this blanket approach to protection of information. It really has to be an approach that is based on the circumstances of each particular case, and there shouldn't be any hard and fast rule that prevents the disclosure of classified information, notwithstanding the existence of public interest in the matter. And in that regard, I mean, there are many analogous situations regarding public disclosure for the sake of the public interest, and that being a defense. And so in terms of the case law, we can see that there should be, number one, a flexible approach, and number two, a public interest defense is absolutely indispensable in order to ensure that freedom of expression is not thrown thrown out of the window in a piece of legislation of this nature.
I understand that Wentzel will be making submissions on this bill on behalf of print media. Why is the new Protection of Information Bill regarded as unconstitutional by many?
If it is passed in its current form, what we will have is a piece of legislation that fails to strike the proper balance between the legitimate need for protection of certain state security matters and the right to freedom of expression, as well as the right of access to information, which is also another very important right which is protected under our Constitution.
Thank you, Okyerebea.